Hello, this is the lecture on chapter 22. It will be online on the 8th of April. The module, I've set up a module on Canvas for small claims. If I have a comment about your assignments or anything about the small claims, it will be in the module that's labeled small claims, so you can look there. What I would like you to do on the 8th is question 2 will be on, the assignment will be there. I would like for you to carefully read the directions. Make sure that the witnesses that you're telling me about in question number 2 are ones who are going to be able to prove the facts you told me about in question number 1. I would like you to look at a video, and I'm putting the link on Canvas to this video. It's called The Monkey Business Illusion. Some of you may have already seen it. It's pretty popular in a lot of different kinds of classes. But I'd like you, if you have not, it's only a few minutes, and I'd like you to watch that because I think it's a good comment on witnesses. If we were in class, we'd be watching it together and preparing our witnesses in class together. What I want you to do is you kind of have to do this one by yourself. And preparing witnesses is what you should always do if you're going into court for anything and you're taking people with you that you want to have testify. You need to prepare them. Preparing them is never telling them what to say, definitely never telling them to lie. But you don't want to be surprised when you get into court about what they're going to say, and they don't want to be surprised about what you're going to ask them. So make sure you think about that when you're answering these questions. The main goal of the questions that we're doing is not so much that you give me a long answer, it's that you think about it a little bit before you answer it at all. Okay, so I hope you are all well, and I hope that you are able to get something out of this business law class that you are taking. This chapter that we're talking about gets into what is from now until the end of the semester, and that is Article 2 of the Uniform Commercial Code. The Uniform Commercial Code was an attempt to make sure that businesses and consumers would have some kind of similar law in all the states, so that they wouldn't have to keep changing what they were doing depending on what state they were operating in. That was the goal. It's not completely true because not every state adopted the Uniform Commercial Code in exactly the same way, but for the most part, it is pretty uniform. It's got lots of different articles in it. This concentration from now till the end is on Article 2, sales. Article 9, Article 3 are all covered in 1090. So we're talking about Article 2, the law of sales. When we're talking about Article 2, we want to be sure that we understand exactly what it covers. And we need to know what it covers because if there's a problem, we have to know if Article 2 applies. The definition of Article 2, which includes the elements, and by now you know we talk about elements a lot when we're talking about everything in the law. But the definition contains the elements. It is a transfer of title of tangible personal property for a price. So those are the elements. A transfer of title of tangible personal property for a price. And there will be a seller and there will be a buyer. That's what we're talking about. Okay, now what does Article 2 not include? Well, it doesn't include a lot of the things that we have talked about or mentioned or have definitions of before. For example, investment securities like stocks and bonds, not covered by Article 2. If you had a problem involving the sale or transfer of a stock or bond, you would need to look at some other law to figure out what you're going to do, not Article 2. Insurance policies, commercial paper, these are not covered by Article 2. Now, commercial paper is again something that you would talk about in 1090. It's checks, promissory notes, these kinds of things. They're not covered by Article 2. Real estate, and we talked briefly about the definition of real estate in a couple of chapters ago. So if you're talking about buildings, or you're talking about grounds, or you're talking about rights in the lands of another, such as an easement, you're not talking about Article 2. You will need, by the way, to know the distinction between Article 2 and non-Article 2 on the final, the last test. There will be a question that you will have to do, and a big issue in this question will be, does Article 2 apply? All right, it also doesn't apply to contracts for services. Somebody doing something for you. The services contract doesn't apply to Article 2. Bailments that we've talked about in the last couple of chapters, where you give up possession, does not apply. And gifts don't come under Article 2. All right, so let's get a couple of definitions out of the way here that we need to know, because we'll need to know these definitions in the next chapter particularly. But they are the difference between existing and future goods. Existing goods are goods that are already manufactured. You can actually touch them, feel them, they're already made, and they're owned by the person that is selling them. Everything else are future goods. Future goods are ones that are not yet manufactured or are not yet owned by the seller. Those are existing goods. Now, when we get to the next chapter, what we'll be talking about is when does title, ownership, transfer in existing and future goods, and we'll also be talking about when does the risk of loss, if they get destroyed in transit, when whose problem is, who's going to have to pay for that. And so for both of those, you need to be able to tell, are they existing or are they future goods, because there might be different laws that apply. All right, so back then to what is not covered by Article 2, because sometimes it's easier to define what is covered by knowing what is not covered. All right, so first of all, a bailment. The reason that a bailment is not covered by Article 2 is because when you have a bailment, you have a transfer of possession, but not anything else. No transfer of title. And if you remember, the elements of a sales contract are transfer of title, of tangible personal property for a price. In a bailment, there's no transfer of title. A gift has no price. No money. No goods, nothing's being exchanged, no consideration, no price. So it's not Article 2. Services, well, you can't touch somebody giving you a service. It is not tangible personal property. One of the elements is not there. Okay, so what happens when you have a contract where you have goods and you have services both in the same contract? For example, let's say that you go to a store and you want to have a garage door opener installed. As part of the price, they are going to provide the installation. What kind of a contract is that? Is that a contract for the garage door opener, or is it a contract for the installation of the garage door opener? This makes a difference because when we get to the chapter also on warranties and some other things that you might talk about with a sales contract, it matters whether or not it's a sales contract or not a sales contract. What we have to look at is what is the dominant element. And I have a link on Canvas again, and I know you would have had to have listened to this if we were in class, but for now it's up to you. But sometimes these just stick in your head as a good way to remember it. But it is a song, and it talks about, it's the mixed contract song, how you figure out whether it is a contract for the sale of goods or whether it's a contract for services. And this comes up often. What if you were going in to get your hair colored? Well, are you going in there because it's the product that they use, that's why you're there, and that's what the service is all about? Or are you going in there because you like the person who does it, and this is, whether it's whoever it is that's doing your hair, that's the reason that you entered into this contract. You don't care what product they use, that's irrelevant to you. So which is that? When does that become important? Well, it could become important if you leave and your scalp is burned. You've been injured, where do you look to the law to cover that? One of the first things you have to start off with is it a sales contract or isn't it a sales contract? All right, some of the things that we're going to talk about next here are, we've already covered all of these when we talked about general contracts. And if you recall back then, I told you that when we got to the end of the book, some of the things that we talked about in how you form a contract, how you put it in writing or don't put it in writing, would change a little bit when we got to sales contracts, because they have some specific rules that apply to sales contracts. Well, that's where we are now, and that's what we're talking about. So what I'm going to do through here is just briefly talk about the differences between the common law contracts that we've been talking about and the sales contracts that it talks about in this chapter. I'm assuming that you remember what we talked about when we talked about how contracts are formed, what the elements are, what an enforceable contract is, and now what we're talking about are the changes. That's what we're going to focus on. All right, it's much easier maybe to make a sales contract than another contract, because all we need when we're making a sales contract is you've got to show that people intended to make a contract. Intent is a really big deal in the law. We talk about that a lot. You have to show the people intended to make a contract. They weren't joking. They weren't doing a preliminary negotiation. They weren't seeing if you were interested in the idea, but you wanted to make a contract. You wanted to enter into something that would have consequences if it was breached, if somebody didn't do what they were supposed to do. Okay, so once you show that you have that intent to make a contract, all you need to show is the subject matter and the quantity. Those two things. Everything else we can fill in for you. We can go and look at different market things for price. We might go look at the market price, or for time, we look to reasonable. There's the law, Article 2 of the sales, the law, we would look at that. But those are the only things we want to see in the contract. The subject matter, what is it you're making this contract about, and how many, what's the quantity, that's it. Okay, now this Article 2 applies to new and used goods, and it applies to merchant and non-merchant sellers. Now, a merchant seller is somebody who is in the business of selling the goods. Okay, that's a very simple definition. They're in business, they're making money off of this, they're in the business of selling goods. Everything else is a non-merchant seller. Both of them are covered under the Uniform Commercial Code. There are some different rules for merchant sellers. We kind of expect that merchant sellers have a little more sophistication, they know more what they're doing in the business world, and so some of the rules for them are a little stricter, a little bit different, and they have to abide by that set of rules. Okay, for example, in an offer, a merchant can make a firm offer. A firm offer made by a merchant is one that they promise to keep open for a certain length of time. In order to show that you have a firm offer, one that's not going to be revoked before the end of that time period, the merchant it has to be a merchant. They have to say they were intended to keep it open. You've got to be able to show that intent to keep it open. It has to be in writing, and it has to be signed by the merchant. It doesn't need consideration. You don't have to pay to keep it irrevocable for 3 months. You can just, if you talk to this merchant, they're making you an offer, it can be open for 3 months. If they say they're gonna keep you open for 3 months, it's in writing and it's signed by the merchant. All right, now all contracts have to be accepted. The rules under the Uniform Commercial Code are much more flexible than they are under a common law or general contracts that we've been talking about. Now, if you want to make your offer very strict, if you want to make it so that it can only be accepted in one particular manner or one particular time, you can put that in your offer. That's okay. But if it's not in your offer, then the rules are much more flexible. And what the rules basically say is that the mailbox rule, which is the minute it hits the mailbox, the minute the acceptance is out of your control, it's effective. The mailbox rule applies to any reasonable method of communication. So we don't have to worry about email, we don't have to worry about letters, we don't have to worry about any other kind of communication. Any reasonable method, mailbox rule will apply. As soon as it is made, it's done. Okay? Unless you say in your offer differently. All right. Now, one of the things that happens a lot in this buying and selling is that one person will make an offer, another person will come back with an acceptance, and they won't be exactly the same. If you remember, under the general contracts, we had the mirror image rule. And the mirror image rule said, if you made an offer and someone came back to you, unless what they came back to you with was identical to what you said, it was a rejection and a counteroffer. Not true now when we're talking about sales contracts. The mirror image rule doesn't apply unless the offer says it has to apply. If the offer says you can only accept this on exactly the terms that are in it, then you can only accept it by going with the exact terms that are in it. Okay? But that is not usually the case. And what happens is that many offers are forms, the acceptances that come back are forms, and they contain additional terms. Now, in this section, this chapter, the next chapter, and I think one or more of the chapters, there are charts in the book. And these charts are really helpful in understanding what it is we're talking about. And in this particular chapter, in my book, it is on page 417. And if you can read these charts, you're going to go a long way towards understanding what's going on. Okay? So you have, let's say that you come in and you are talking about non-merchants. So we either have a merchant and somebody who's not a merchant, or we have two people who are not merchants. There's a non-merchant involved. If there are additional terms, not different or conflicting, but additional terms in the acceptance, then you have a contract on the original terms. The new term would have to be specifically accepted before it became a part of the contract. That's if you have a non-merchant involved. Now, if you are talking about additional terms and you have a merchant, both sides are merchants, we expect them to have a better sense of business, I guess, a little more understanding, a little more sophistication, so we have kind of different rules. And the rules are here that, and again, assuming that you have this contractual intent in here, there's no question you're meaning to make a contract. Then the additional terms, if they are material, it's a real big change in this contract, then you will have a contract without the additional terms. You have them on the ones that went out in the first place. That additional term would have to be accepted. If you have an offer that says you can only accept it exactly as I've made it, then you have a contract on the original terms. If you have objections to the additional terms, you have a contract on the original terms. If nobody objects, it's not a material change, the offer didn't say it had to be exactly the same as I made it, then you have a contract that includes the additional terms. That's what I'm saying, if you can understand that chart, you would probably understand what I just said to you. So look at that chart, make sure you can figure that out. All right, now if it's conflicting terms, if it absolutely shows you meant to make a contract, the conflicting terms just cancel each other out. And that can happen often when people use forms, because nobody really reads every form for every specific contract they have, and then you wind up having these contracts, and one says one thing and one says the other. They just, as long as you have that intent to make a contract, then those terms just knock each other out. All right, so we're looking at the contract. What are the terms of the contract? Well, first of all, price. That's not one of the things that has to be in a contract, in a sales contract. So if it's not in the contract, then the price, it will be a reasonable price at the time of the delivery of the goods. It's usually the market price, okay? And we can use different things to determine what market price is. Actually, you can use eBay, you can use Etsy, you can use the online places if you have to establish a market price. Or you go out in the market, that's where you find your price. Okay? There are ones that are a little bit different in this, and that's an output and a requirements contract. In an output and requirements contract, there's no quantity stated. And if you recall, one of the things that you have to have, and there's only two in a sales contract, is that you have to have the subject matter and you have to have the quantity. Outputs and requirement contracts, one where I'll buy everything you make, the other you'll make everything that I need, are exceptions to that rule. They are specific types of contracts. They are used in business, and they're definitely exceptions to that rule. They will be upheld if the whole thing is done in good faith. The parties have got to act in good faith, and the amount that they want the other side to make or the other side to sell them has to be reasonable based on their past practices, things that have gone on before. Like 1 year you couldn't be operating under this contract and you order 100 widgets, and then the next year you want 100,000. That would be an unreasonable jump. That would make the contract probably non-enforceable at that point unless you wanted to do it. Okay, but that's an exception to the rule that sales contracts have to have the quantity stated. All right, so what if it doesn't say how long the contract is going to run? Well, then it's a reasonable time. And reasonable time is a reasonable time under the circumstances that would be decided by a reasonable person. Okay, you can modify a sales contract, meaning change it after it's been made, and you do not need consideration. You don't need to pay for that modification. Okay, the parole evidence rule applies, just like it did before, that outside evidence can't be brought in to change a contract. It's complete on its face. The big difference here is that it is not presumed that a sales contract is complete on its face. In an ordinary contract, if we look at something and it looks like it's a contract, and it's got contract, it's got signatures at the bottom, it looks, all the terms are filled in, then it's complete on its face. We don't have that presumption. You have to be able to show that this contract is complete on its face. And that's why I asked you to look at some of the sample contracts that I've given you, or the sample contracts that I've put online, and you will notice that in almost all of them, towards the end, there is usually a paragraph or a statement in there that says, this is our entire contract. The reason that statement is in there is for this reason, that if you have a dispute about it, remember, if you don't have a dispute about the contract, then who cares? But if you have a dispute about that contract, they're going to look to see, is this the whole contract? If you want to bring in outside evidence to show that something is different in the contract than you thought, you have to be able to get it in. The parole evidence rule is going to apply. So, depending on who's the plaintiff, you're either going to have to show that this is the entire contract, or you're going to have to show, oh, no, there were other things that we just didn't have in here. This is not the whole contract. That's a difference from the general rule, okay? So remember, the parole evidence rule does apply, but there's no presumption that what you're looking at is the whole contract, okay? In interpreting contracts, sales contracts, we do use course of dealing and usage of the trade. Even though consumers are brought into the Uniform Commercial Code, Article 2, to me, anyway, it always seems to be a little more weighted toward business. I mean, the original goal of this was to make laws for businesses to be uniform across the United States. So we look at these and we assume that businesses have been working together for a little while, and that they have built up a past practices kind of thing. And we're going to probably assume that their course of dealing, what they've done in the past, is what they continue to do, had intended to continue to do in the future, unless it says differently. Unless they say, no, this is going to be different, then we're going to assume that you meant to continue doing what you had been doing. And we assume that you are going to, whatever is the standard in your trade, your industry is, that's what you're going to do. Usage of trade. If you're in the business and the other person is in the business, then you probably both know what people usually do in your trade. And we're going to use that to interpret contracts if there's a dispute. Bulk transfers, just throw in here because I had a student before who had a problem. He was transferring to another state, and they wanted to make sure that he had covered bulk transfers in business law, and we don't do it because bulk transfers are almost, they're gone because bankruptcy law came in and bulk transfers became irrelevant. And so we had to write a big paragraph about why we didn't cover bulk transfers to go to this other state. I have no idea why that was a requirement. All right, form of a sales contract. Well, and a lot of you got this wrong on the last test. I told you about it. They have changed the amount. They were going to revise Article 2, and the committee that was doing this pretty much assumed that everyone was going to go along with these revisions in Article 2, and they didn't. In fact, when you got this business law book, the first ones came out with the old way. Then for a few years they came out with this book that had both, and students had to learn both the old Article 2 and the new Article 2, and the pages were all split down the middle with the old and the new. Well, the states didn't adopt the revisions uniformly, and so they took out the new revision, the new revised Article 2, because some states adopted part of it, some states adopted it and made changes to it, but it was not as universally accepted as the task force, the committee that was doing it, expected. So one of the things that's different depending on the state you are in is the statute of frauds. The revised edition recommended $5,000. Michigan adopted $1,000, and in Michigan, if you ever need to know this, it's MCL 440.2201. We have the $1,000, but it's not $500. So in Michigan, anything over $1,000 needs to be in writing. Okay, so what kind of a writing do you have to have? Well, you have to show that a sale has been made, and you have to show the number, the quantity of goods involved. That's it. That's all that has to be in your writing. If you're going to be suing somebody over it, though, there has to be a signature. If it's a confirming memo, you have to have the merchant's signature. We'll talk about confirming memos in just a second. But you have to have the signature of the person that you are complaining about, I guess you do that. You want to, if you want to show that they entered into this contract and now you need to sue them, then you have to have their signature on there. Okay? The writings that you have can be documents that you put together. You just have to have something to show that there was an attempt to make a contract, what you were talking about, and the amount you were paying. Now, there is such a thing in this area as a confirming memorandum. And these, you're generally talking about merchants confirming memo. If you are in business, these confirming memos are very important. You cannot just throw them aside and go, oh, okay, that's what we said. Because you have 10 days to object. If there's something in a confirming memo that you don't feel is correct, you have 10 days to object. If you don't object, then whatever it says in that memo, it's presumed that that's your contract. That's what you wanted. So you have to, in your business, big or small, you have to somewhere in your practices and your procedures, you have to spot these confirming memos when they come in, make sure somebody is reading them, and make sure that whatever it says in that confirming memo is in fact what you agreed on. Because if it's not, you better object, and object in a way that you're going to be able to prove that you objected. All right. There are some exceptions, of course, because this is the law. There are exceptions to the rule about everything being in writing, the statute of frauds, and that is specially manufactured goods. If goods are going to be made to your specifications, they're going to be made specially for you, there's something about them that's different. You didn't just go in and say, oh, I'll take that one off the floor. Then you don't need a writing if the manufacturer, the seller, has made a substantial beginning to the manufacture of those goods or to procuring the materials that are needed to make those goods. You know, if you get a whole bunch of materials and it can only be used for this particular contract for you because it's for some reason it's specially made for you, the contract doesn't have to be in writing. All right? If there is a receipt and acceptance, it doesn't have to be in writing. I mean, it's kind of hard for you to come back later and say, oh yeah, I took these 100 widgets and I'm using these 100 widgets, but we really had no contract. Then why did you take them? Things just showed up on your doorstep and you go, oh, okay. If you accepted things under a contract, then the contract doesn't have to be in writing. If you paid for goods arrive at your business and you paid for those goods, it's kind of hard then to argue that there was no contract. Why did you pay if there was no contract? Okay, so those are exceptions to the rule. And there's another exception that we didn't really talk about when we talked about going to court, but it's something that's called an admission. Some people get admissions and confessions mixed up. They're not the same thing. But an admission is a statement that you have made in pleadings, that's the paperwork you filed with the court, in testimony somewhere, or a court order, where you admit to something. And for example, in discovery, if you are at a deposition and you say that you've ordered these goods, then that would be considered an admission, and that's an exception to the requirement of the statute of frauds that it be in writing. Okay, there is an international law for the sale of goods, the contract for the international sale of goods. It, however, does not apply to goods that are bought for personal, family, or household use. This is kind of a business, a commercial approach to it on the international level. And you're going to hear that phrase often, personal, family, and household use. Generally, you're speaking about then a non-merchant, but you're talking about things that are used in the home. And this comes up again in the chapter where we talk about warranties. All right, leases. Leases finishes up this chapter. Leases are now covered in Article 2A. Leases originally weren't that big a deal. People did not, ordinary people did not lease cars. People didn't lease furniture. People didn't lease TV sets. It didn't, I mean, that just was not a big thing. Now, it is. So we have a lot more non-merchants, a lot more consumers that are entering into leases. And technically, these leases were not covered by Article 2, because what a lease is, it is when you get goods, but you get the right to possession for a certain period of time for a price. But you don't get title in a lease. And so they weren't covered by Article 2, but they've become so popular that now they have their own little section of article. It's Article 2A. And what you need to know from these is that there are some different kinds of leases. It's a very brief talk that they give on leases in here. So what you would need to know from it is that what a lease is, that it is, you give someone the right to possession for a period of time for a price. Okay? There are consumer leases, commercial leases, finance leases. Consumer lease is one where the goods are going to be used for personal, family, or household use, not business. Okay? A commercial lease, when it's not a consumer lease, it's a commercial lease. If you're using the item for business, it's not a consumer lease, it is a commercial lease. And then there's this third finance lease, used more primarily by businesses, where it's a three-party lease. You have a lessor, a lessee, and a supplier who goes to the person who's providing the financing. It's a more complicated form of a lease, but you always, in this case, have three parties, not two. Okay? Leases have to be in writing. Usually, if the payments over the term of the lease are going to be more than $1,000, which pretty much covers most leases, even when you're talking about furniture leases. But it doesn't talk about how long the lease goes for. It talks about how much money has to be paid under the lease. It has to be authenticated, whether it's online, signature, whatever, it has to be authenticated by the party that you're trying to sue. Okay? And the record, whatever it is that you're preparing for your writing, it has to say what the leased goods are, how long the lease is going to last, and say that this is a lease. Okay? And then when we get to warranties, and we'll be talking about warranties a lot more in another chapter, but when we get to warranties, you look to the supplier of the goods for the warranties, not the person who let you lease them from them. You look to the supplier of the goods. Okay, although this seems like a long chapter in writing, so much of it is simply pointing out the changes from the chapters that we have done in the last section. Thank you.